Hours earlier, deputies are already building a picture. Restaurant staff describe a couple who stepped out repeatedly to smoke throughout the night, then after ordering dessert, left one at a time and never returned. One restaurant's tab nearly $400, the other at least $250. Under Florida statute section 509.151, obtaining food or lodging with intent to defraud, walking out on a restaurant tab with intent to avoid paying is a crime, not just a civil debt. Below $1,000 in value, it is charged as a second-degree misdemeanor. The key word legally is intent. A genuine billing mix-up is not the same thing as fraud, and the statute says so directly. The vehicle matching the restaurant's description is located and stopped for the taillight. Standard procedure so far until the deputy asks the driver to step out. Under Pennsylvania versus Mims, 434 U.S. 106, decided in 1977, an officer may lawfully order a driver, and under the later case, Maryland versus Wilson, 519 U.S. 408, decided in 1997, a passenger to, out of a lawfully stopped vehicle without any additional justification. Before any questions, the deputy reads an advisement of rights, even though at this point the subject isn't under arrest and isn't yet in custody. Courts have held that Miranda warnings are constitutionally required only for custodial interrogation. Under Berkemer versus McCarty, 468 U.S. 420, decided in 1984. Reading it early doesn't create an arrest by itself, but it does mean the right to stay silent is on the table from this exact moment, whether or not it's later used. What follows is a fairly ordinary roadside conversation where he lives how long who his girlfriend is until the questions turn to food. 2 croissants at a 24-hour bakery, fish tacos at a restaurant he can't quite name, a candlelit dinner spot with a large fish sign out front. He remembers atmosphere in detail. He's vaguer on names and vaguer still on exactly how much he paid and how. Then the deputy lays out what the restaurants actually reported, 2 calls to tabs. And she says surveillance footage placing him at both in the same shirt without paying. He doesn't go quiet. He offers an explanation, then a second one, then a third. Cash left under a plate, maybe a confused waiter, maybe simply not proven 100%. This is where the encounter's real hinge point sits, not in what happened at the restaurants, but in how the conversation is handled right here. Multiple shifting explanations for the same event are not proof of guilt on their own, but they do give an investigator more material to check and more opportunities for the story not to hold up. At one point unprompted, he tells the deputy he doesn't want trouble because he's a lawful citizen. It's a common instinct reaching for a credential that feels protective. Legally, though, citizenship has no bearing on whether a state theft of services statute, Florida statute section 509.151, applies to anyone standing on that roadside. Deputies separate the couple, a standard lawful investigative technique, and question her alone. She says she's originally from Russia, lived in New York for 11 years, and is now with her partner, referring to him at different points as both boyfriend and husband. Asked how he normally pays, she says every time by credit card, then moments later says he sometimes carries cash. It's a small slip. It's also the single clearest contradiction in the whole encounter. Separating co-suspects isn't a trick or a rights violation. It's one of the most basic tools in investigative interviewing. 2 honest, independent accounts of the same real event tend to match. 2 accounts built to cover for each other tend not to. A restaurant manager is brought to the scene for a show-up, a one-person identification common when a witness is available within minutes of an incident. Deputies read the standard admonition. First, the person shown may or may not be the one involved. And it's just as important to clear an innocent person as to identify the right one. The reliability of a show-up like this is tested under Neal versus Biggers, 409 U.S. 188, decided in 1972, and Manson versus Brathwaite, 432 U.S. 98, decided in 1977. The manager confirms no cash, no card, nothing left on the table when the couple walked out. With 2 independent restaurant reports, surveillance footage, and now a contradicted account from both subjects, the deputies make the call. Florida generally requires that a misdemeanor occur in an officer's own presence to justify a warrantless arrest, the baseline set out in Atwater versus City of Lago Vista, 532 U.S. 318, decided in 2001. But Florida statute section 901.15 carries specific exceptions allowing a warrantless misdemeanor arrest based on a reliable victim or witness report for certain property offenses, which is what the deputies are relying on here. Once under arrest, a search of each subject is standard procedure, checking for anything that could pose a safety risk before transport. Nothing unusual is found. Both are transported to the station, and the booking process begins the quiet, procedural end to a night that started with 2 bottles of wine and a bill nobody agrees was ever paid. The acute stress response narrows attention to the immediate threat. Under pressure, he answers biographical questions fluently, then hedges on the specific questions that actually matter: what he ate, how he paid, how much. Once confronted with a contradiction, bargaining and minimization are common stress responses. 3 different explanations inside 2 minutes give an investigator 3 separate things to check, not one. Isolation during a separated interview can increase anxiety and push a person towards statements that feel consistent with what they assume their partner already said, rather than what they personally observed. That's exactly how one generalization collapses into its own contradiction here. Continuing to talk after being told the story doesn't match the evidence is an ordinary human response to disbelief. Most people try to talk their way out rather than stop talking. Not one invocation of the right to remain silent changes what the restaurants already reported. It only adds more on the record. At the moment he was confronted with contradicting evidence, he chose to keep offering new explanations rather than simply confirming the basic facts already established by the restaurant reports and video. Measured against the right to remain silent available to him from the first roadside advisement, this added self-generated inconsistency to a case that didn't need it. Declining to speculate further at that point would not have changed the reports or the video, but it would have left nothing more to weigh against him. When asked about her partner's payment habits, she chose to generalize every time, always, rather than describe only what she personally saw that day. Measured against ordinary interview practice, generalizations are easy to contradict, and she contradicted her own within the same answer. Speaking only to direct observation would have removed the clearest inconsistency deputies relied on. Deputies chose to separate the 2 subjects before individual questioning. Measured against standard investigative technique, this is a legitimate, non-coercive method that surfaced a real contradiction without any physical tactic, a decision that holds up against the applicable standard. One deputy chose to tell the male subject early on, "I know that you're lying to me. I can tell by your body language." Measured against interview best practice, confident accusations based on demeanor are a known soft spot. Body language cues are not reliable deception indicators, even though the underlying evidence, the reports in the video, was solid on its own. Leading with that evidence instead would have rested the confrontation on its strongest footing from the first sentence. The citizenship status of the people in this specific case is not established by this footage. But suppose the same situation, the same stop, the same questions, the same arrest happened to someone who is not a U.S. citizen. The legal picture changes in ways worth understanding for anyone watching this who isn't a citizen themselves. First, for a non-citizen, a charge like the one in this case can carry consequences beyond the criminal penalty, immigration consequences up to and including deportability or a bar to re-entry, separate from whatever a court decides. Even in arrest, a pending charge or a plea deal can matter. The specifics depend on the exact charge and the person's individual immigration history. This is general information, not a prediction for any one case. Second, the right to remain silent and the right to an attorney belong to everyone physically present in the United States, not only citizens. That protection does not extend the same way at a border crossing or a port of entry where different rules apply. Third, never give a false name and never present false identity documents. For a non-citizen, doing so can be a separate crime on top of the original issue, carrying its own serious immigration consequences. Don't hand the other side a second case against you. Fourth, if arrested or detained, a foreign national has the right under Article 36 of the Vienna Convention on Consular Relations to have their home country's consulate notified. It is a treaty right. U.S. courts are split on whether it is individually enforceable in a courtroom, So treat it as a right to assert, not a guaranteed remedy. This is general information, not legal advice. The immigration consequences of any charge are complex and change often. Only a licensed immigration attorney can advise on an individual situation. Whatever actually happened over that bill, the pattern in this footage is one we see again and again. The legal exposure was set by the restaurant reports and the video before either subject said a word. Everything said afterward, every new explanation, every unprompted detail only added to the record. Staying calm and knowing when silence is an option doesn't guarantee a different outcome, but it never makes the outcome worse. If this kind of breakdown law footage behavior is useful to you, subscribe for the next case file and drop your read on this stop in the comments.